evening, everybody. My name's Sam De Silva. I'm the chair of the BCS Law Specialist Group, and welcome to this evening. I appreciate you giving up the famous interview. We'll try to be as entertaining as that, but obviously if we're not, you can always dial off and join it at 7 o'clock. So I think we're quite lucky here. We've got a number of leading technology lawyers here who are going to talk about the book that the BCS has published. So firstly, I'll introduce you. We've got Sara Ellacott, who's the EMEA Assistant GC for Litigation at Oracle. She advises on all areas of IT sector and has a wide experience of dispute resolution procedures, including negotiated settlements, high court litigation, arbitration, and mediation. And she speaks regularly on these topics. So hello, Sara, how are you?
Hi, evening.
Good. And then we've got Jeremy Holt here. Jeremy, I hope you don't take this the wrong way, but you're probably one of the, I guess, most well-established and probably one of the first IT lawyers in the UK, aren't you?
Keep talking, De Silva. Keep talking.
So Jeremy specialized in technology law for about 30 years, and in 2003 he helped set up in Swindon the first museum in the country dedicated to the history of computing, and he's co-authored 2 other books on IT law as well. And then we've got Jeremy Newton, who's director of Codified Legal, a specialist in technology and outsourcing law. He's a past secretary of the Financial Services Specialist Group of the BCS, and he's, like Jeremy, got 30 circa years of experience in IT law and contracts. So advises on a wide range of IT law, outsourcing, wide variety of clients, and current Chambers directories rank him as one of the leading IT lawyers. So welcome, Jeremy.
Thank you, Sam. Good to see you.
Yes, and one thing that you guys probably won't be aware is that both Jeremy and Sara used to be my bosses probably about 20 odd years ago. So it's quite nice. Them, instead of appraising me, I get to ask them the hard, tough questions this time. So I'm looking forward to that.
The apprentice has become the master. Yeah.
Can I make it quite clear? I had nothing to do with you, Sam. It's not me who was your boss.
No. I may have learned something if you were, Jeremy.
D'accord. D'accord, as the French would say.
Okay, so we'll instead of the banter, we'll get on with the actual question. So, Jeremy, there's a question for Jeremy Holt. Where did the original idea for this book come from?
Very good question. Thanks, Sam. Yeah, I can remember thinking that there wasn't a decent book to explain in layman's terms a lot of the concepts to do with IT law. I've been involved in IT law for quite a time, and I used to go over to America, buy everything I probably could, because in those days America was ahead of us in relation to IT law. Now I think it's the reverse. And I'd buy various books, but they were quite technical. They were very well written. They were quite technical. And I thought, well, there's no real sort of basic guide. And I tend to be the kind of person that if I think something needs doing, you know, the road to hell is paved with good intentions. It doesn't really count unless you go and get your hands dirty and try and do it yourself. Now, I think it's quite appropriate that this is a meeting of the Law Specialist Group of the British Computer Society, because it was through the Law Specialist Group that the book came into existence. Because if you go back about 22, 23 years, I was the secretary of the Law Specialist Group, and I dealt with the newsletter. And so I put a kind of advert in the newsletter of the Law Specialist Group asking whether anybody would be interested in helping get together and writing a book, a basic guide to IT law. I was absolutely amazed when a number of very good-hearted people came back and said, yes, they were interested. So I invited them all to a meeting in the city, and you know, I got out the statutory flip chart, and I went around the table and said, look, I'd like each one of you to mention a couple of subjects that you think we ought to cover in the book. Just give me 1 or 2 subjects and we'll slowly build on that. So I went around the table and I wrote up on the flip chart the subjects that they suggested. And having done that, I said, look, we're going to need to divide these up. I'll now go around the table the other way, and I'd like everyone to volunteer for 1 or possibly 2 of these. and I'll take the runts of the litter, as the sort of editor. I'll take the ones that nobody else wants. And it was just like something in a film, because they all went round and they picked various things, and there were two things left at the end. One was IT contracts, and the other was employment law aspects of IT law. And I thought, goodness me, those are the only two subjects I know anything about. So this is God's way of telling me that this ought to proceed. So I asked each person, I got an approximate chapter size, asked each person to get something ready. We had a bit of difficulty finding a publisher for it, but eventually the BCS stepped forward and agreed to publish it. I mean, I'd never been an editor of a book before. Not that I'd ever been involved in any kind of book before that time. And from the start of the first idea of the newsletter going out to the actual production of the book took 5 years altogether. I think later editions took probably a shorter length of time than that. That was partly because we were looking for a publisher. So there's a lot of lag time in the production of these kinds of books. I mean, 1 year, 2 years is nothing. I think this has really taken about 2 years to go through. And I mean, I was amazed, to be honest, that I could find real experts in the field, such as Jeremy Newton and Sara, who were prepared to come forward and write chapters. But I think, if you're dealing with very talented people, it's not what's in it for them. It's whether the particular project interests them. And if the particular project interests them, they're quite likely to help out. Jeremy, do you want to add anything to that? Jeremy Newton, do you want to add anything to that?
Well, no, not really. I mean, the genesis of the book was it was your idea, and you came to me and said, how about sharing some of the work on editing this? I think what I'd add really is who the book is aimed at, because from the outset we intended it to be useful to a whole range of IT managers and IT professionals at all levels of seniority, really. I mean, this is a British Computer Society publication rather than a Law Society publication, so it's computer people rather than lawyers who were the target market from the outset. And the thought process was that you might be starting your first programming job just straight out of university or straight out of sixth form. You might just be completely new to the industry and just have an interest in the subject. There might be more experienced people. There might be IT managers or chief information officers or IT directors who'd been responsible already for negotiating a whole bunch of major IT services contracts or software development contracts or those kinds of things, or perhaps for implementing IT policies for staff or data protection policies for the company, those kinds of things. So it was really targeting IT professionals at all levels of seniority. They're not legal specialists, but they are people who need to know enough about the law to be able to do their own job functions properly. So we also hoped that it was going to be useful as it was never intended to be a legal textbook as such, but we thought it would be helpful for legal advisors who need to know a bit about IT law. I mean, this is emphatically not the kind of IT law textbook that you're going to get on an undergraduate degree or a postgraduate degree. I mean, I think it is actually used as a reference source on some courses, but there are much heavier volumes around from Oxford University Press and people like that, where they really sort of drill down in massive detail into the case law and the statutory background of IT law. But the point of this book was that we hope to be able to explain legal concepts and principles in a non-legalistic kind of way. That was the reason for writing it. So it's designed for non-lawyers to find useful. And we've made a point of asking our contributors to write it that way, and I think that's the way it's come out.
Okay, no, thank you for that. It's a useful sort of overview in history, plotted history. I was wondering, Jeremy, when you were going to get to the end, but you did, so that's good.
Who are you talking to, Sir Silver? There's two Jeremys here.
Yeah, be specific, Sam.
Talking to you, Mr. Holt. Mr. Newton, in terms of someone saying, look, I've got the first edition, I've got the second edition, why should I get the third edition? What's new here?
Well, there's new stuff and there's old stuff. This is I actually just to, preparing for this call this evening, I had a look at the second edition, and I was a bit gobsmacked to see that it was actually came out 2010, so it's 11 years ago now. I had honestly forgotten that I had written 3 chapters of this book, which have not stood the test of time. One was
didn't you get your associates to write those, Jeremy?
I would never do something as important as delegate the writing of a chapter of a book that was in my name to some associate, Sam. Yeah, there was a chapter on system procurement contracts. There was a chapter on outsourcing, and I think I had another chapter. Oh, I had another chapter about doing business online. So yeah, 2017, I think. Jeremy Holt calls me up and says he's been having a chat with the BCS about possibly bringing out a 3rd edition of the book. And we went through the chapter list and said, well, what is there in here that we could probably drop just for reasons of space, and what is there getting on for 10 years on that is missing that we think we could usefully include. So those 2 or 3 chapters that I just mentioned, the ones about system supply contracts and outsourcing contracts, we felt those were more commercial matters than legal ones. There are lots and lots of other sources of information about computer contracts. Almost any big law firm's website is going to have a bunch of information about computer contracts, but there's also precedent services like Practical Law Company and organizations like that. So there is a huge amount of information. If you need to know how to put together an IT contract, there's lots of good starting points for that. The chapter about doing business online, which 10 years ago, 11 years ago, seemed to be a really important chapter because the whole distance selling e-commerce directive landscape was changing as we all got accustomed to doing business electronically. Now that's so mainstream. It's effectively, it's a huge, vast, discrete body of law by itself. So we thought, well, we can't really cover it in, we can't do justice to it in a 10 or 15 page chapter. And for that reason, we decided actually it was better to drop that rather than to do a super high level job that was really worthless. Other chapters that we dropped were the chapters about the WEEE regulations, the waste electrical and electronic equipment regulations, which was a really technical chapter. And we thought, well, the people who need to know about how to dispose of stuff properly, they'll have their own advisors dealing with this from the environmental law point of view. Again, it's not something that everybody who works in IT needs to know about, so we thought that was a bit too specific. And then there was a contract as well about source code escrow that again was a useful chapter to have in that edition, but we thought it was probably sort of surplus to requirements. And the reason for that was because there was lots of new stuff that had become incredibly important in the intervening 5 or 6 years. So the new sections include 2 chapters about GDPR, one of which is about the principles of GDPR. As everyone will remember, GDPR came into force in the UK on the 1st of May 2018, and across Europe, in fact, on the 1st of May 2018. So that was going on, the transition was going just as the chapters were being written. So there was a chapter about GDPR itself, the big concepts of GDPR. There was a chapter about exceptions and certain key provisions that we thought were worth flagging up separately. And then there were chapters about as well about cybersecurity. I mean, one of the really exciting things for me when I was editing this book was Andy Lucas's chapter about cybersecurity. That was just incredibly useful, incredibly informative. I really enjoyed that. And the other new chapter was about agile software development, which again has taken on a currency in a life that I don't think people had really foreseen 10 or 15 years ago when the previous editions of this book were being conceived. So those are the big new chapters for me. There were several topics as well where actually not a great deal of new work was particularly required. Sara's chapter on resolving disputes didn't need much rewriting at all because the dispute resolution mechanisms and the pros and cons of those haven't necessarily changed that much over the intervening time. The intellectual property chapter didn't change a great deal, though of course Brexit has threw a bit of a spanner in the works with that. But that's a you know so that's a quick summary of what's gone and what's new and what's stayed pretty much the same.
Okay, that's really useful, Jeremy. Thank you. Now, sort of turning into some of the sort of, I guess, the more interesting sort of, I guess, detail of the sort of book and some of the concepts. Sara, so in terms of an IT project, you know, what are some of, in your experience, what are the signs that it's the right times to call an IT litigator?
Well, I suppose from my perspective, it's obviously the sooner the better. But, you know, I can kind of appreciate, I now work in-house as an in-house counsel, and therefore I'm on tap for my clients to call me, speak to me whenever they feel the need. But for someone who would be looking to, you know, employ the services of an external counsel where there's a cost implication, then deciding the right time to call that expertise in, I appreciate, is slightly more nuanced. But I suppose my view on this is that, as a general point, disputes are often, quite rightly in many cases, viewed as in a very negative way. But if you handle a dispute properly and appropriately, certainly for my side of the fence, where I've tended to act more for suppliers over my career, if you can actually handle your dispute well, your customer will sometimes actually thank you, and you come out with a much stronger and better relationship. So it doesn't necessarily have to have a very negative connotation when you start to consider you may well be in dispute with your supplier. It doesn't have to end badly. And I think that's, for me, the most important thing is going in with the right attitude of exactly what you're trying to get out of the process, is because it can work out to both parties' advantages if you use the correct tool and you pick up the issues quickly. Now looking at picking up those issues quickly, I think some of the obvious ones that we'll all be very familiar with on particularly large scale or larger IT project disputes. I mean, if you're starting to see milestone dates slipping on a relatively regular basis, that's going to sort of set some red flags for you as the customer, or it certainly should be. You need to be asking those questions. Changes to functionality questions coming up. We thought we were getting this. It doesn't appear to be what's being put on the table. You know, as soon as those sorts of questions start to come across your desk, I think you should start to be thinking about how you approach your supplier to answer some of those questions. As I say, it doesn't have to be an aggressive approach at these early stages. It just needs to be an open conversation and an open discussion. Scope creep is another one. We've all lived with that as IT lawyers for many years. For me, those are the kind of obvious sort of areas that if I was on the other side, I'd be wanting to start to think about speaking to somebody as to what's the best way of ensuring I'm asking the right questions, ensuring I'm using the tools set out in my contract to help me. You know, for example, change control. You guys on the side of drafting probably spend ages drafting sometimes complex change control processes. And I can put my hands up, 9 times out of 10, neither side decides to utilize that change control process.
I've always had my suspicions. I've always had my suspicions.
I mean, I do feel, I also, you know, when Jeremy Newton and I feel so sorry that he's there, and you, Sam, negotiating for hours, various contracts and incredibly complex interrelationships between the rights of each party to do certain things. And both sides often ignore them. So look at your contract. It's there. It's not to be stuck in the drawer, as we always say. It's a living document. It's one to read. And in a way, it's like to take some of the emotion out of the problem that you're facing, because you can say to the other side, look, we already agreed in this scenario, we would do X, Y, and Z. So it doesn't have to be an aggressive act on either side. So yeah, I mean, those are my sort of highlights that I would be looking out for, to be wanting to talk to an IT specialist. And I would definitely say, get the contract, brush it down, have a read, and utilize the processes that the lawyers that you've employed in the past to draft for you, to make your lives easier. Utilize those.
Okay, so that's really useful. Thank you. Yeah, excellent. Mr. Holt, so you've been doing this a long time. So, what are the sort of the main changes you've seen in software licensing over the last 20 odd years or so?
Okay, I mean, it's a subject close to my heart because I've lectured. One of the things which I've done, as well as being a practicing lawyer, is I've worked as a part-time as a lecturer, initially for central law training, and then later for MBL. So there's all kinds of people who've been scarred by listening to me on this subject. And it's also how I met Jeremy Newton, because we were both lecturers at a conference. I mean, on something like software licensing, there hasn't been that many changes. I think two of the things which I would mention, and certainly if you do many IT acquisitions, you come across this a lot more. The question on due diligence is, are you using any open source software? The answer is much more likely to be yes than it was 20 years ago. So if you're looking for the changes, the rise of open source software, the greater use of open source software. Apart from that, the transition to storage in the cloud as opposed to on site, and also as an alternative to the standard software licensing, the use of software as a service in replacing the standard software licensing. There's still a lot of ordinary software licensing going on, but in many ways it's being delivered in a different way. I mean, the other thing is that if you go back 20 years or so, most of the contracts would have been English law. Nowadays, the world's much smaller than it was. And so on a day-to-day basis, any kind of IT lawyer is very likely to be asked to look at a contract which is subject to a foreign governing law, subject to a foreign jurisdiction. And one of the things, I worked for a chap called Ronnie Fox, who's a bit of a legend amongst legal circles, mostly as an employment lawyer. But one of the things that he taught me when I was newly qualified is that if you had a foreign contract, there was nothing to stop you. You're not allowed under Law Society SRA rules to comment on a foreign contract because you're not qualified in that particular jurisdiction. But what you can do is a kind of legal fiction, and clients find this really helpful, is to say, look, sorry about this. This contract is to the client. Sorry about this. This contract is subject to the law of Delaware. I'm not a Delaware registered lawyer, but what I can do is I can read through this contract and comment on it as if it was subject to English law, and I'll give you my comments. If the contract is worth a great deal, what I suggest is I'll put my comments in a letter or an email, and then we can take it off to a Delaware lawyer and say, these are the comments that have been already made on this contract. Are there any additional points that you want to make because of any particular quirks of Delaware law? And I'm often asked when I'm lecturing about IT contracts, which states I would accept for jurisdiction, and which states I wouldn't. And I've got myself in a lot of trouble over the years, but there's no reason for not to continue the process. And I normally say that the more rattlesnakes there are in the state, the less I would accept it for jurisdiction. So therefore, I would accept Delaware, I would accept Massachusetts, I would accept New York, I would accept California. But once you get down to the more idiosyncratic, I think that's a word that I can't be sued for, but the more idiosyncratic states such as Mississippi and Delaware, where I'm told that if you're an out-of-state plaintiff, you're just not going to get very far. It's, back to the old expressions, you ain't been in these parts very long, have you? Anyway, I've been criticized for the rattlesnake analogy because apparently there are lots of rattlesnakes in Texas. So so therefore what I've been saying is complete baloney, and I would advise everybody to ignore it. But I don't know if Jeremy, Newton, or Sarah want to add anything to what I've said.
Well, so Texas is a challenging place to be in the courts, definitely. So I wouldn't want to put it.
Is that right?
Yeah.
All right. I rest my case about the rattlesnakes then. I just, a prophet has no honor in his own country. Jeremy Newton, do you have any comments on what I've said?
No, my experience is if we get a document that's in English law, and it happens that's in the English language, and it happens to be governed or subject to the jurisdiction of a different country or a different state of the United States, it is our duty to say to our clients, we can't advise you definitively on the meaning of this contract. We can't advise you on what your rights and remedies are if it all goes wrong, or how easy or difficult they might be to enforce. We can't advise you on any of that stuff. However, if you want us just to take a look through it and see whether it appears to contain a license for the software you're buying, or a clear description of the service you're taking, and some kind of remedies if the money doesn't get paid, and some kind of resolution mechanism if it all goes wrong, we can, I can tell you that, but I'm not advising you on the legal implications of it. Now, absolutely, strictly speaking, you need to go and get advice overseas, and I have to tell you to go and do that. But the clients don't want to pay twice for the same advice. And if it's a client that I've worked with, some cases we've worked with the same clients for 10 or 15 years, they're quite happy just to sort of take a punt on getting a business view of it rather than a strict legal view. That seems to work.
Okay. No, I agree with all that. We had a exercise for one of our sort of trainees and so forth, and the trainee got one of the associates to help out with it, and he said he helped out, and he was like sort of reviewing a software license and stuff, and I go, oh, that's interesting, but he said it was so many questions he didn't get to the end, and I quickly looked at the governing law and go, you did mention it's governed by Congo law, didn't you? And he goes, no. So it's like, yeah, that's probably the first thing you need to look at, the governing law clause.
So
it is absolutely.
So Sam, what is the rattlesnake situation in Congo? I'm not up to date with this. I mean, are there many rattlesnakes in the Congo?
I have no idea.
It's not called the Congo now, isn't it? Zaire or something?
I mean, it is challenging because I cover EMEA now. I read a lot of contracts from a lot of different countries. And a lot will be the same, and we would be able to make very similar observations. And then, of course, there are some little small changes, and certainly in civil code countries as against, common law countries. And therefore, you do ultimately have to say, I can give you a feel, I can give you a view, but I'm not a qualified Dutch lawyer, for example, so I don't know the Dutch civil code. Where they take, for example, fairness as a concept far more into account than we do under English law. So, we do have to step carefully around that topic.
Yeah, and then you've got those issues of, the whole concept of warranty law in Germany is different. Warranties in Germany are different, and there's no concept of an indemnity at all. Yeah. So, but obviously it depends on from a business perspective, it depends on the scope and the nature of the project. And if it's, if you're a big bank and you're spending just £10,000 or something on procuring a data feed, well, you're not going to want to spend £20,000 on legal fees getting it lawyered. Yeah. All you're after is a quick feel.
Yeah, I agree. Mr. Newton, sort of turning now to sort of from software license agreements to software development agreements, what have the changes you've seen in the last 20 odd years?
The good old days where you used to get a software engineer turn up with a bunch of disks in a suitcase and say, "Where's your server? What time can I disconnect it?" Well, I mean, there's been the whole way the world works has changed really. Leaving aside the actual delivery of the software, which of course is all done remotely now. The big change, the very current change we see in lots of software development contracts is now that agile methodologies have caught on in a huge way. So it used to be the case that in a beautifully crafted software development contract, the starting point, what I'd always say to clients, was the foundation stone of the whole thing was the specification of the software. This says what the software that's going to be developed, what it's going to do, what it's going to interface with, how it's going to work, how data flows around within the system, how things interact with other things. And there was a clear specification. There'd be then a process of coding, testing, rectification, retesting, until you get to the summit of the entire process, which is acceptance, final milestone, deployment, and go live, and then the thing's finished and everyone goes away happy. The contract for that might be a fixed price contract. We will pay you £1 million to deliver this system for us. Go ahead and do it. Or it might be a T&M project. Well, we'll pay you a certain amount of money, perhaps subject to a cap, to go away and develop this system for us. But one way or another, it was something that was fairly definite in contractual terms. The big difference with Agile, of course, and it's something that a lot of lawyers still fail to grasp, and this does cause problems. The big difference is that when you're contracting with an Agile methodology, you're really contracting for a process. You're not contracting for a fixed, set, predefined deliverable. You are bringing together, you're drawing together expertise from the supplier organization, the customer organization, you're throwing them together and you're saying, this is how you're going to collaborate. This is how it's going to work. You're going to go into a room, you're going to do your scrums and your sprints, and every 2 or 4 weeks, you'll get your head above water and you'll look around and you say, okay, how's it going? How's it working? What do we need to fix? What do we need to drop out of this project? And you perform several iterations of that until you reach an endpoint. So what it means in practice is that you don't start with a kind of cast iron guarantee that you're going to embark on a project and at the end of it you will have a super duper new system that will perform and be compliant with every single requirement in the 1,000 pages of requirement specification you might have. It's in the nature of Agile that functionality might get dropped as the project goes along. It's also in the nature of Agile that new functionality might get added as the project goes along. So what you're defining there is a collaborative process. You're defining the way that the parties are going to work, and what that means. And this is kind of anathema to lawyers, because what we're trained to do, what we practice doing our entire lives, is trying to bring clarity and certainty and precision to a project so that everyone knows you do this, we do that, at the end of it you get paid X. Of course, the collaborative element of Agile means that you get some blurring of the boundaries of responsibility about who's responsible for errors, who's, well, to use a kind of a very loose word, whose fault it is if something doesn't quite work. Because of the greater degree of customer involvement, customer collaboration, you can't simply point at the supplier and say, well, look, it was your fault because you were doing the development. It's much more interactive and participative than that. So there's a blurring of responsibility. There's also, that goes with that, a degree of loss of financial control. The customer organization doesn't necessarily know that it's going to just pay X and get to the end point for what it was hoping to achieve. So that's one of the big changes. Now, Agile plainly is working and does work for many development projects. But legal advisors to customer organizations, and I'm speaking as somebody who advises both customer organizations and service providers. Lawyers in particular, I think, because of the way we're trained, we tend to put up resistance to Agile because there is this perception that it's uncertain and that it doesn't fall into conventional contractual boxes that just assume a customer will pay a certain price and get a certain deliverable at the end of it. So that's one aspect of software development I think has changed. The other main change, of course, is the uptake of open source licensing, which has been around for decades, certainly. But now it's very prevalent. It's in every industry. In fact, Andrew Katz's open source chapter in the book, which I think is the longest single chapter of the book. It's a very, very comprehensive chapter. But it just shows the extent to which we are development on open source in almost every development project to some extent. And regardless whether that open source is officially introduced to the project or not, the chances are that somebody on a big project team is going to be dipping into some open source library and taking something from there. So that's a risk as well. There's this sort of contaminative anxiety about open source being deployed in proprietary software development projects. But I'd say that's a very long-winded answer I've just given you, Sam. I realize I've been rambling for 15 minutes, but that's in my view, last 20 years, the advent of Agile and the take up of open source, the big changes in software development contracts.
Thanks, Jeremy.
And the Agile just makes, as Jeremy said, it sends shivers down, certainly down a disputes lawyer's back, because one of the things you're trying to do is apportion blame. You're either asking a third party to apportion blame in the adversarial routes, at least, and that becomes very, very, very difficult, particularly when you're talking about cooperation. How much cooperation? What's reasonable cooperation? It makes life very difficult, certainly in a court environment, which is, I suppose, in litigation, which is one of the most traditional forms of dispute resolution we have. It's very difficult for a judge, even a technically, competent judge, to make those assessments. So, when one is thinking about dispute resolution in the IT arena, I think those are some of the things we're thinking about more now, is where is it best placed to have somebody consider those concepts and make a decision which will either allow the project to carry on rather than just come to a complete and utter end, and how that decision can be made quickly, because it's a nightmare, but mildly. It's very difficult.
And I think one of the worries is that people sometimes talk about Agile contracts. We're going to do this on an Agile basis. We don't need to bother writing a specification now. It's going to be Agile. And people sometimes use that as a kind of pretext for signing up to a contract, get it signed, get it into this year's figures, or get it into this year's budget. And the Agile methodology is kind of used as a bit of an excuse for not bothering to do the thinking, the hard thinking up front about what the specification is or should be, because people have their, they've got other priorities. And I think that's a misuse, and that's why I think it does cause problems in many cases. It's the lack of forethought.
Agree. I don't know about you guys, but drafting an agile contract, if you're sort of instructed by the client to draft it in a pure agile basis, that gives me a bit of concern, because there's very little certainty and prescription around it. You might as well just have a document and the parties will agree to do everything and leave it at that.
And I think our job, certainly as external legal advisors, is to just say to our clients, well, look, that's fine. You do understand this, though. You do understand that you don't get as much certainty with an agile contract as you do with a conventional one. As long as they understand that, as far as I'm concerned, my job's done.
Yeah. Okay, Sara, question for you. So expert determination, mediation, arbitration, litigation. Unfortunately, these terms are sort of bandied around, used interchangeably. You know, people think they're the same thing. Can you sort of just summarize sort of each quickly in terms of the core sort of ingredients of each?
Yeah, so just take a deep breath. Yeah, I mean, it's the question of how much information to share, and I'm going to try and keep it relatively high level, not to bog everybody down in the detail. What I would say is that it is worth giving some upfront thought to this. And I know often contracts will be, the governing law, the jurisdiction clause will often be treated as a sort of boilerplate kind of clause, and not necessarily everybody's given it a whole lot of thought as to, in this particular type of contract, what would be the most appropriate type of dispute resolution if we were to get there. And there are horses for courses. You know, litigation isn't the right thing for every dispute. And it seems to me it is worth giving it some thought, because particularly in the area that I now spend most of my time in, not all of my time, but most of my time in, which is, I suppose, large-scale projects, moving across into cloud projects. It's really, what do the parties want to get out of their dispute resolution? Are they, you know, if it's straightforward, if you're talking about, you know, you owe me money, for example, not an IT issue as such, but, you know, it's a debt issue. You just want somebody to answer that question, yes or no. So you could potentially use a more adversarial process, litigation, an arbitration, something that's got a simple outcome. But if you're knee deep in a project ongoing for a couple of years, and you hit a snag, hit an issue, hit a dispute, you don't necessarily, for both parties, want to throw the baby out with the bathwater. You just want to get the issue resolved, maybe some compensation changing hands, maybe some changes to the timetables agreed, and then you just want to get back to business. And therefore, a form of dispute resolution, for example, like expert determination, I'll start with that one, might be more appropriate for the parties to consider using. So I say that. So let's look at expert determination first. I mean, I don't know about the rest of you. I remember about, I mean, obviously it's been very popular in the construction industry for a long, long time. And there were some people, an old colleague of Sam and Jeremy's, mine, a guy called Tony Bales, who was very much pushing expert determination in IT contract disputes 20 plus years ago, because he'd seen how useful it had been in the construction industry as a way of resolving issues that are coming up on an ongoing project so that the parties could get back to work quickly. And I'm still, I suppose, quite surprised. I don't know how the others of you have come across it, but I don't come across the use of expert determination that often. I had assumed we would see a bigger take-up in the IT industry than we have. And the upside of using it, as I say, you get an expert, an independent expert will come in. It's a quick process. It's pretty much a quick and dirty process. Both parties make their submissions about the issue, about the problem. And that third-party expert, within a very short period of time, often no more than a month or 6 weeks at a maximum, will give you a very quick decision. And he will apportion responsibility, won't use the word blame, but will apportion responsibility for the outcome of the dispute and make suggestions as to moving forward. And that's enforced. That will then become the contractual basis. It's an enforceable as breach of contract. And then the parties, if they accept that outcome, can move on and get back into the deal and the project and move forward. Many people have said they were thinking of using it. In my experience, I've involved in various disputes and people have contemplated it, but I've really not seen a great deal of take up, which does surprise me, I have to say. But it's very much a quick, more informal way of resolving a dispute, which allows the parties to keep their relationship on track. And I think for many IT contractor environments, that's a really good thing to do. The other type of dispute resolution process, which I think falls more into that bucket, is mediation, which again uses a third-party external expert, either a legal expert or a technical expert. You can make your choice. It's slightly more formalized because we've now got mediators who have been working in this area for 20, 25 years plus. It's now a fairly well-established dispute resolution process in the UK, at least. CEDA was set up, gosh, when I remember sitting in the room with Carl Mackey when I was a trainee who set up CEDA. So we're talking a good 30 years ago. So it's a well-established route of resolving disputes now. And again, you have the third party who will bring the two sides together and will listen to both of their positions, but won't make a decision. That's the difference with a mediator. A mediator will not tell you what he or she thinks is the right answer. He will try and bring the parties together to try and see if they can come to a mutual agreed way forward. And if you can, then that agreement can be documented in a settlement agreement, which will then be binding on both parties for moving forward. And I think the good thing about that is that you can be quite creative. The parties can think outside the box as to the ways that they can resolve their disputes, which more formal processes such as arbitration or litigation don't allow you to do that. So, you can come up with different concepts of, well, if we do this, or if we change the project, if we change the documentation, there's a lot more room for flexibility for the parties to think of better ways of moving forward. And again, it allows the parties' relationship to have a fighting chance of surviving. And again, I work now for a supplier, and I've acted for suppliers throughout the majority of my career. The idea that a supplier wants to be involved in a formal dispute with their customers makes little sense. A supplier wants to be in a good relationship with their customer. They want a successful outcome of the project or the service. They want you to come back to them at a future point. So the idea that a supplier won't want to try and resolve a dispute in a positive way, I think is a misunderstanding that some people have. Therefore, mediation allows the parties to take that more conciliatory process and work together. So I put, I suppose, expert determination and mediation in the more conciliatory, work together ways of resolving disputes in the sort of formal pantheon of dispute resolution. Obviously, the more adversarial routes would be the traditional form of litigation, and now, obviously, fairly traditional too, arbitration. It's been around for a fairly long time. I'm sure most people are familiar in some shape or form with litigation. It's clearly both sides very much taking each other on in a court, in a very adversarial process where there is a winner. And there's little room for subtlety. So if you've come to the end of your tether and you see no future relationship with the other side, then, litigation can be the way to go. It will give you that definitive answer. It may take you 3, 5, 7, or the case I have in Saudi, I'm still on 11 years. It may still take you plenty of time to get the outcome that you're hoping for, but it will get you there at the end. It will be a formal decision. You know, judges in the UK, particularly in the technology courts, over the last 15 to 20 years, have certainly gained in their experience of understanding technology. But as we've been talking this evening, things moving quickly. Most cases, you have to bring in an expert or two to help a judge understand the complexities of the issues that they're being asked to opine on. So that certainly increases the costs of utilising that form of dispute resolution. Arbitration, for me, arbitration, I have to say, I don't view it as being very different to litigation in many respects, although, you know, clearly you're not in a court environment. But the parties have obviously agree to appoint either one or three arbitrators to again come up with a definitive outcome on the dispute. Plenty of formal arbitration bodies exist that have very clear processes as how an arbitration would run. But ultimately, at the end, they're going to come out with a formal decision which is enforceable. And it, you know, I suppose the one benefit you could say of arbitration is that the ability to enforce a judgment more widely in different jurisdictions is available, whereas, you know, a court decision in the UK or a court decision in Spain on the whole are enforceable only in those jurisdictions, where an arbitration decision will be enforceable under the New York Convention in other countries. So, I mean, in as a very, very high level, those are the four main forms that we as dispute lawyers look to, and try and look to choose one which will best suit the facts that we are facing if we're not involved in the contractual element of deciding that. But certainly, I would say that there is still scope for growth in expert determination in the IT arena. I think that I've had two come up in the last 6 months, so that tells me, I think, that there is a growing interest in trying it out. And it's certainly the most effective way of allowing the parties to continue with their relationship after a decision is being made. So I would certainly suggest that people give it some thought, maybe more so than we have in the past.
Okay, thanks, Sarah. I don't know if you find this interesting, but you know, in most expert determination clauses we have, you know, if the parties can't agree, you know, they will go to the precedent of the BCS.
Yes, lucky you.
Well, no, I've spoken to a number of precedents of the BCS, and I've said, "Do you know you're mentioned in these contracts?" And they had no idea. So it's interesting how that has sort of that kind of phraseology has been included. Jeremy, was that your doing, Mr. Holt?
Why am I responsible for this? I'm appalled by the suggestion. Yes, well, I mean, in the old days, you'd use the head of the Institute of Chartered Accountants of England and Wales, and they'd get £250 for sticking a pin in a document somewhere that was a list of expert witnesses who were prepared to do it. Yes, I mean, it would be a good idea. I don't know whether the BCS actually has a sort of standard wording that they'd like to use, but you're right. I mean, you know, one refers to these august people, the president for the time being of this particular organization, and they probably charge for choosing someone. Yes, I'm not a litigator. My firm actually does. We made a conscious decision to employ no litigators and never to get involved in litigation because we thought it lowered the tone of the organization. So everything that Sara's quite rightly with hindsight, but everything that Sara has been telling me has been completely new to me. As a commercial lawyer, one of the things which I am really keen on, and I always do, unless the client tells me not to, is to put an alternative dispute resolution clause in there, because I'm massively in favor of alternative dispute resolution so that there's no you know, there's no sort of Maxwell immediately, you know, go straight to court. So there's a kind of interregnum, 6 or 7 weeks, where people are trying to sort it out and tempers cool down. And, you know, I mean, good litigators would do that anyway, I think. So you're only formalizing something that you would like to happen in those circumstances. But as far as litigation is concerned, I speak from a position of absolute and total ignorance. So I'd better shut up.
I have to say, my favourite, my personal favourite form of dispute resolution is mediation. Certainly over the last 15 years, I've found it to be a really successful way of resolving parties' disputes. And even more so because the English courts at least now ask the parties very much up front, have you considered mediating your dispute? And if not, why not? So, you know, you're just answering that question before the judge even gets to you anyway, so it gets you some brownie points. But 9 times out of 10, mediations will be successful, if not on the day, but often within a week or so later, when people have thought about it a bit more. You know, the famous saying, of course, is a successful mediation is when both parties walk away thinking that they've been hard done by.
It's a bit like the BBC, really.
That's when you know that it's worked. Because
Sara, sorry, we're talking about dispute resolution. We've got a question, so I'm sort of scanning through the question. There's a question specifically for you, Sara, and on what's your views on online dispute resolution? Online, oh, yeah.
As in sort of doing a court case or mediation via Zoom or
yeah.
Actually, I've actually found it really successful over the last year. I've done 3 mediations via Zoom, and they worked really well. The mediators, you know, you had separate meeting rooms and people join in another meeting room, and actually it was really successful. I would happily mediate over Zoom, particularly if you're mediating with customers in different countries. Made life a lot easier for all of us. I have done a court hearing over Zoom, which lasted a long time, 7 hours. But that was more because the person on the other side was not in a good shape. And was a litigant in person. So the judge was bending over backwards to make sure they had plenty of time to get over the points they wanted to make, particularly on a Zoom call. So that wasn't, I mean, it was fine. If we'd been in court, I'm sure a judge would have stopped them a lot sooner. But on the whole, I think the legal profession, certainly for disputes, has coped very well over the last year, and I'm perfectly comfortable of attending a case management conference call with the judge on Zoom or Teams. We've not had any real issues, so I think it could be certainly a good way forward, as I say, for international mediations or arbitration hearings. It will certainly cut the costs and all the parties having to convene somewhere in London, for example, which is often common for an arbitration hearing. So I think there's some merit that we might carry on using it even when we open up again.
Yeah, thanks, Sara. I think the question I'm just looking at, I think they were more focused on the retailers, the online dispute resolution, you know, the European Commission platform, you know, for retailers and so forth. I guess that's more consumer, isn't it?
Yeah,
really?
I'm afraid I don't have any experience with that, I'm afraid.
Yeah. Okay, that's fine. Okay. Mr. Holt, there's a question I was going to ask, and I think one of the audience members asked this. What are sort of some of the key contractual issues to consider in a SaaS contract, software as a service agreement?
Yes, I mean, Jeremy Newton, do you want to answer that? I mean, I thought that we.
Coward.
I
Okay.
thought I was going to cover licensing, and my learned friend was going to cover software as a service.
I don't think that's what we agreed, but I'm very happy to talk about it.
We
yeah,
better have
so,
an expert determination in that case.
So Sas contracts. Okay, so the this is, obviously software as a service has superseded traditional software licensing contracts, and so much software functionality is now delivered on a service basis. So like I said a few minutes ago, you don't get the engineer turning up with a box full of floppy disks and asking where to put them in, like in the good old days. There is no software download. There is only an implementation, and the customer makes use of the software remotely, never has it loaded on the customer's own system. So the key issues from a software as a service perspective, in my view, are really twofold. I mean, one is the relative lack of flexibility in the contracting models, because it's in the nature of software as a service that it's close to a one-size-fits-all offering. It's the nature of that, the economies of scale that you get that make software as a service so attractive, or cloud computing so attractive. So there's a one-size-fits-all service delivery model, which means that you don't have much scope for negotiation. You might have a little flexibility around the terms and conditions or the pricing, but you probably don't have a lot of flexibility in what the service itself consists of, or the service levels to be met. So that's one area. The other area tends to be in the terms and conditions themselves, because many suppliers of software on a SaaS basis are very large companies that offer only inflexible terms and conditions. There isn't really much scope for negotiation, and in many cases those terms and conditions are pretty one-sided. So if I'm advising, let's say, a financial institution on a traditional software deployment, we'll probably sit down, there'll be an implementation plan to work out, there'll be some development, perhaps some integration costs that go with that. And there'll be the opportunity to go through their terms and conditions and have a conversation with an account manager or an executive about things like termination rights and remedies and what happens if it all goes wrong. Whereas in the SaaS world, these terms and conditions are kind of presented to you. I mean, if they're presented at all, they might just be on a website. You just go and click on those and sign here using DocuSign, and off you go. So I think those are the big issues. It's the one size fits all nature of it, and then the inflexibility of the T's and C's that are the corollary of the benefits of the economies of scale that SaaS brings.
Okay. Can I just add, when I'm lecturing about this, one of the things which I say is, if you're going to enter into a SaaS contract, it's a bit like getting married or buying a company. It's going to be pretty difficult to later to unravel it, to go back to the start again. So it would be sensible to do a huge amount of due diligence on the potential SaaS supplier, and really to ask them any question that you want, any reasonable question. Any SaaS supplier should be prepared to answer any reasonable question that you ask of them: how many customers they've got as an installed user base, how long they've been involved in this field, what standards they operate to. So it's too late once you've jumped out of the plane to check what the warranties were about the parachute. So you need to sort of get everything sorted out before you press the button to go. And of course, SaaS only works with the incredible developments that have been over the last 30 or 40 years in relation to bandwidth and the reduction in cost of storage. Neither of which, I mean, without those two things, those two aspects, reduction of the cost of storage and the massive increase in bandwidth, SaaS would never have been able to get off the ground. And I think, 26 years ago, I helped set up a law firm. We had to get our own computer system. We had to install all our software to do with the computer system. I love things that break up the market, that disrupt the market. If someone's setting up a new law firm now, you could make a decision in the morning to set up a new law firm, and you could have the new law firm running that afternoon, because there are specialist SaaS suppliers who will supply everything that a law firm is likely to need, via SaaS, and you don't have to go and buy any hardware, and you don't have to go and buy any software.
The big single issue, though, from a customer perspective in the world of SaaS is what happens to my data if it all goes wrong, if the solution is unavailable, if the company goes bust, if a disaster hits, and how do I get my data back? That's not actually, I haven't got my arms around it in the way that I used to have in a traditional deployment. And that's the one thing that you really need to get some clear assurances and some clear contract terms about, is what happens at the end of that contract, and how can I be guaranteed that I can get my data out of that server that's sitting in Nevada or Omsk or somewhere, and how can I get that back into where I need it? So that's the one really critical issue that I would advise clients to look for now.
Okay, good. I'm just looking at some of the questions from the audience. I'm going to summarize them. One of the questions was security requirements. Does the book cover how to sort of draft or review security requirements in a contract, or guidance?
It doesn't cover how to draft them. I mean, we've actually steered pretty clear in the book of trying to explain how things are drafted, because there are plenty of examples of contract templates out there. I mean, there's some good ones and there's some bad ones, but the book does deal. There's a very good chapter about cybersecurity and the sources of cybersecurity law and regulation. What standards should apply? What are mandatory? What are optional? What's nice to have? So there is good guidance in the chapter by Andy Lucas about cybersecurity. Really worth reading.
Okay, great. Another question is, how is the best way to effectively get your sort of non-legal colleagues sort of on board in terms of getting the due diligence done on cloud, on SaaS contracts? How do you convince them, particularly if there's no in-house legal team, that due diligence is really important?
Well, I think I'd tell them a whole lot of scare stories about people only asking questions after the thing has been entered into. I mean, Jeremy Newton's quite right. SaaS suppliers are massively inflexible about their standard terms. They really don't want to have different contracts. They want everybody to be on the same kind of contract. There has to be a very good reason for them to change. So, I think I would just tell them stories of where things have gone wrong, where people haven't done the due diligence. I come back to the fact that certainly my experience dealing with SaaS suppliers is that they will answer any reasonable question that you ask them, because everybody will look at things in a different way. Ask them about standards, ask them about history, ask them how long they've been involved in it, ask them future intentions and whatever. As long as it's covered by a confidentiality agreement, they should be quite open with you about things that are happening. And I would, if they're not prepared to answer various questions, to me, that would ring a lot of alarm bells. So I think the normal way of getting people to do things is spreading fear, uncertainty, and doubt. So the usual FUD argument, and telling a few war stories about things that have gone wrong in the past.
Okay. Another question we've got is,
it only needs to go wrong once,
Yeah, lesson learned.
I agree.
It doesn't have to go wrong many times. It just needs to go wrong once, and you can find yourself in for a long haul, a costly, painful long haul. And what I often appreciate that I'm a grudge purchase. I do know that. So one of my favourite things is I was doing I settled a matter for one of our internal clients, and he looked to me in the end. He said, it's been an absolute pleasure. You're a lovely person. I've really enjoyed working with you. I hope I never see you again. Because if you get down into a gritty, grubby dispute, it can be a very long haul. So if people want any stories on those, I could happily provide them with many. It's worth doing. It's one of the questions I was looking at as to, what can customers do to avoid getting involved in disputes and being sued. And I think what both Jeremys have just said is upfront effort and work is the #1 way of protecting yourself. Do your early due diligence. It's 101. It's the best way.
Great, thank you, Sara. Another question we've got is basically software licensing. Can be quite complex, nuanced, particularly with open source. So, the individuals looking at sort of software licensing, not necessarily experienced or trained in IT law. So, what approaches? Quite a very general question. What approaches would you recommend for managing these risks? And is there sort of a basic level of training you would sort of suggest for these individuals?
Well, I'm happy to answer the software licensing side. Perhaps Jeremy Newton could follow me up on the open source, because he knows more about this than I do. I mean, I think the first thing which I'd say to the customer, the licensee, is what do you want? Where do you want to use this software? Because I wouldn't make the license any wider than was actually necessary, because there'd probably be cost implications. I'd also say, well, if it was a huge success, we don't want to be stiffed by the supplier if we want to widen the number of companies in the group that might use this software. So I would have written into the software license that if we chose to widen the number of companies in the group that use this software, then we got it on a pro rata basis, number of users. So there wasn't a massive increase by the supplier. So first question is, what do you want and what do you need now? And then looking forward, if this works well, if it's rubbish, of course, we just switch the taps off and we never trouble them again. But if it's a success and it works well, and you'd like to roll it out elsewhere in the group, what would be the maximum that it would be used for? And can we get some kind of deal organized with the supplier? Which most suppliers are absolutely, they think it's absolutely fantastic if you say, well, we just want to use it in this company now, but we might want to roll it out throughout the whole group. And of course, they want to know where people are using it. So we shouldn't be frightened of saying where they are, and we shouldn't be frightened of them from time to time coming in and checking, or getting a third party to check that we are actually using it within the terms of the software license. If we argued about that in any way, I think that would be a bit of a red flag to the supplier, because it's important we come to the deal with clean hands. So those would be the two major things that I would say to somebody who was tasked to deal with that.
Yeah, before we talk about open source specifically, I think, Sam, I just kind of gathered from the wording of the question there that there was a slightly different nuance to the question, which was, if you are not experienced at reading, reviewing, negotiating software licenses, what sort of do you just pitch in and have a go at it, or what should you be doing to prepare for that process?
That's correct. Yeah, it's more about more about where do you get help, or how do you go about it? Yeah.
So personally, I'm a great fan of clients being trained. Certainly, all the regular clients that my firm has. Okay, not absolutely every single company that comes through the door, but the people we're doing business regularly with on over the course of years, and maybe handling 3, 4, 5 contracts per year over the course of several years. It's really worth it's something that we can give back to them, is free CPG training, which involves sitting down with their IT management and saying, okay, look, you don't need to pay a law firm thousands of pounds to negotiate and comment on every contract for you. Here are some things where you can actually, okay, you might need someone who's experienced in drafting to deal with some of the subtleties, but you can understand contracts by understanding some very basic concepts. in the context of a software license, for example, you might need to understand what's the difference between a license being exclusive and non-exclusive, or a sole license. Why does that matter? So there's probably about 10 points. Sara, look, you know this better than anybody else on this call, but there's probably about 10 points that are really, really critical in any software licenses. Exclusivity is one of them. Scope of use is another. The way that the thing is it priced per user? Is it priced according to the volume of transactions processed? Is it priced in some other way? And there are lots of sources of training about software licensing or computer contracts more generally that range from like a half-day course run by law firms or by legal conference organizers. There's plenty of training online about these basic concepts. And they'll go up to, you could spend a full like weekend course learning the ins and outs of different kinds of software licenses. They're very sort of flexible tools. The whole concept of a license is that it's flexible, can be varied all sorts of different ways. It's infinitely variable. So there are lots of sources of training. I would suggest for those clients who use large law firms for their IT law contracts, those law firms themselves, and Sara and I have done this in the past when we were in practice together, those law firms themselves will often do training for their clients, particularly training about new areas of law like GDPR and those kinds of things as those new areas of law come up. But they'll also do general training on commercial contracts and on contract drafting. But if you've got a good relationship with specific lawyers, whether they're in big firms or small firms, lawyers should be prepared to do that kind of investment in their client relationships as a matter of course anyway. So I think there are lots of opportunities, there are lots of potential sources of training to equip people at least to get started in the world of negotiating software licenses.
Okay, thanks, Jeremy. Sara, there's a question for you. You talked about expert determination. So the person was wondering, in your sort of experience, do you find that customers find using an expert a bit risky if they think that they've got it wrong? i.e. the supplier's not at fault, they're basically the customers not done something according to the contract, and therefore they don't want an expert.
Yeah, well, that would be risky. That would clearly be risky, because if that can be easily and clearly shown, then the expert is going to come down on the side of the supplier and make his comments appropriately. I mean, if you felt that aware of your position, I would be thinking that you'd be looking to commercially negotiate a resolution before even considering expert determination or any other formal dispute resolution process. I mean, many contracts that you guys will draft, of course, will also have escalation to senior management in there somewhere. So if you're in a situation where you're not feeling that strong, I mean, I would utilize the softer dispute resolution available, such as discussions between senior management. Even if it's not in the contract, actually, I would offer that as a way of breaching the impasse. So yeah, I mean, from either side, if I am looking at something and I'm not feeling overly confident or comfortable with our position, or it's just not something that we wish to, see formally dissected, then I would bring a dispute resolution commercial outcome forward and try and get the parties round the table, just to sort of close the deal on the issue.
Yeah.
Yeah. I mean, if you're feeling if you've either been advised or your own investigations show you that you're not in a strong position, I certainly wouldn't be advising any clients on either side to be investing what could be some considerable time and money in fighting a case which doesn't look that good. I mean, let's cut to the chase and let's try and get the parties around the table and moving forward. You know, at that stage, as they say, the only people that win are the lawyers. So let's, you know, get a commercial decision made.
Yeah, okay. Mr. Newton, I know you feel quite sort of strongly about this area. SLAs, service level agreements, you know, what are sort of the traps for the unwary? You know, how can our sort of audience, our IT sort of practitioners, make this more, you know, workable and more efficient?
Service level agreements. Oh my goodness. Right. So if there's one big thing that everyone needs to know about service level agreements, it is that the terminology that you come across is incredibly muddled and variegated. And what one company calls a key service level, another company calls an operational service level, and what one company calls a critical service level, another company calls a KPI, and what one company calls a performance indicator, somebody else calls something else entirely. And when you're negotiating contracts, I mean, okay, in the SaaS world, for example, the service level agreements tends to be sort of written in stone, you take it or leave it, right? It's gone. You can't really have much of a discussion about it. You're not going to get much luck out of Amazon Web Services or someone like that if you try to negotiate their SLA. But if you are negotiating a service level agreement, let's say for a big outsourcing contract, like for a bank or a government or someone, you will often find that you sit in meetings and, okay, so as a legal advisor, as a commercial lawyer, you know, you've got to listen. You listen to both sides because you can't negotiate a contract unless you're listening to both sides. You quite often sit in meetings thinking, these guys are talking at complete cross purposes. What this one is saying is a critical service level seems to mean something different from what that one is calling a critical service level. I've got an example of this at the moment where somebody said, what's a critical service level? And one person, and they've been arguing about this for like half an hour, and I just said, I think I just need to tease out, what do you mean by a critical service level? And this guy said, oh, it's a service level that gives rise to a right to service credits if it's breached. And the guy on the other side of the table said, no, that's a KPI. That's a KPI. A critical service level is that critical service level is it's a target service level. It's the threshold you have to meet. That's the critical service level. So there's all this really muddled terminology. So my tip to negotiating, I mean, a service level agreement is it's a set of instructions that says, here is what you are required to achieve, and here is what happens if you don't achieve it. It may be payment of money, it may be some remediation plan, it might be outright termination of the contract. You could have several thresholds of that. You could have, you know, sort of target service level and then kind of acceptable performance, and then, you know, minimal acceptable service level below which all sorts of penalties and things kick in. But the starting point for having any kind of intelligent discussion about this is to sit down at a whiteboard or a virtual whiteboard and define the bloody terms you're using, because otherwise it's just nonsense. And the trouble is that lots of organizations, so I'm doing a contract at the moment that involves a bank. As it happens, on this particular contract, I'm advising the service provider. And the bank tabled its standard procurement contract, which is one of these 200-page long things with like 30 schedules sitting behind it and a template SLA.
But Jeremy, just for the avoidance of doubt, you're not dealing with CMS on the other side, are you?
I am pleased to say I am not, because I would expect a lot more common sense from you, Sam. So it's got this template SLA in the contract, and this SLA has two concepts in it, one of which is a key service level, and one of which is, I think it's an operational service level. But it doesn't say what the difference is. And I asked the question, can someone explain what the difference is? And the response we got from the bank, or rather from the bank's legal advisors, was, well, that's the language we always use. We expect all our suppliers to sign up to it. Yeah,
Sounds like a bank. It sounds like a bank.
I'm not disputing that. I just want to understand in your mind what the difference is. They said they'll go away, they'll define it, and they'll clarify it. Okay, right. So they come back a day later, and they've defined it, and they've defined it as saying a key service level is any service level that is not an operational service level. So you click to the operational service level, and it says an operational service level is any service level that is not a key service level, which doesn't, as I politely pointed out, doesn't really move the argument on very much. So getting this terminology right and clear, and overcoming institutional preconceptions about what these terms mean, because quite often organizations, they've got their own standard procurement contracts, they've got their own standard sale contracts, but those have been drafted by somebody else who might be in head office 1,000 miles away, and the people on the ground are told, you've got to use these, you've got to get them in front of your customer or your supplier, and that's what you've got to stick with. So you're faced with this kind of institutional intransigence and stupidity, and you've got to overcome it. And the only way you can overcome it is it's actually by a kind of mediation process. It's by sitting down and saying, listen, I just want to understand. We're not trying to be clever here. We're not trying to score points. I just want to understand and to be clear that when we talk about a critical service level, we are always talking about the same thing conceptually. And the language that I always use, if I get the chance to draft it first up, I will say, okay, this is what we're going to say. A service level, the capital S and a capital L, a service level is the thing that is going to be measured. So let's take a simple example. It might be availability of a system. Then you have a target service level, which is the standard of performance that is supposed to be met. Okay, so your service level might be availability. Your target service level element name might be availability. Your target service level for that might be 99.9% a year. You might designate that then as a critical service level, in which case you then need to explain what a critical service level means. And a critical service level is one, the failure to meet which might give rise to termination. So you've got to be really, really refined in your definitions. And if there's one thing that I would say to people about the most important issues from a contract perspective for SLAs are define. If it's an availability for SLA, define what available means, define what uptime means, define what downtime means, define how it's going to be measured, define business days and working hours, so that you've got all these concepts. And SLAs, people get muddled about SLAs because they don't invest enough time in just getting that clarity into them. And I'm not talking about making it complicated. I'm just talking about making sure that these important building blocks, and I always think express them as being, they're like Lego building blocks, okay? They've got to fit together neatly. Everything has to be seamless. It's got to be binary. If you define those things, then you won't go too far wrong. But if you try and have a conversation about them without defining them, you are going to end up in a pickle.
Okay. Thanks, Jeremy. I think, believe it or not, that is our time up. So thank you so much, guys, for making the time available. I know you guys are really busy, so I'm sure that the members of the BCS have really appreciated that. I've really appreciated it, and thank you for the support and your useful insight and experiences. I guess, you know, if you were paying for the expertise of Jeremy and Sara, you'll be paying a lot per hour. So, you know, I'd count yourself lucky that you've got a complimentary free legal advice session here.
Oh, is it free?
You didn't read the contract, Newton. You didn't read the contract.
Could have been clearer.
So a bit of a plug. There's a question saying, is a book available on the BCS web bookshop? Yes, it is. And for the next 2 days, if you enter the code IT Law, you get a 40% discount off the book. So yeah, make sure you utilize that discount. It's only available today and tomorrow. So yeah, as I said, I thank you, Mr. Newton, thank you, Mr. Holt, and thank you, Sara. Really appreciate it. Hope you enjoyed that as much as I did. And yeah, I wish you all a safe evening. And yeah, feel free to, you know, I guess, purchase the book and, you know, provide feedback to Mr. Holt if needed. And then
only if positive. Only if positive. If it's negative, I want the feedback to Mr. Newton. He deals with the complaints.
Yeah. Okay. And we look forward to the 4th edition some stage, Jeremy.
That'll be after I've died. It'll be after I've died.
Great. Okay. Well, thank you very much. Okay. That's all. Okay. Bye.
Bye.
Bye.